What begins as a routine bond hearing quickly turns into one of the most emotional courtroom sessions of the day. Multiple defendants ask the judge for another chance, each claiming they're ready to change their lives, while prosecutors argue that public safety and the seriousness of the allegations must come first. One defendant even pleads directly with the judge, promising he has finally learned his lesson. But will those emotional promises be enough to change the court's decision? Stay with us, because this hearing is filled with dramatic arguments, difficult rulings, and powerful courtroom moments.
The people would add a count of larceny from a person and dismiss the unarmed charge. I have had a chance to speak with Mr. Scott, and I reached out to Ms. Kirby about any video. The video came. There's about 15 videos that came yesterday evening. I haven't had a chance to look at them. I'd ask the court to adjourn these matters briefly, keep the offer open so I can.
Our matter is also included in that offer as a global resolution, so I guess we would adjourn also, and I would like to address bond when ready.
Go ahead, you can address bond. I'll set probable cause in these matters will be adjourned June 1st, 2023, 9 a.m. Go ahead, as to bond.
Your Honor, last year, there was a bond violation that occurred on April 17th. Mr. Scott tells me that he had went to the hospital and then he had walked home, so that may have been part of it. And he may have been accidentally outside his zone, but he was just on his, on the sidewalk down the street. So he's unsure if that was part of it also, but he did go to the hospital that day. He is trying to get into outpatient treatment voluntarily. He also has a tutor now available for school. He found out when talking to his grandmother the other day, and he wants you to know that the jail is overcrowded. So he is hoping that you will let him out on a PR or PR with a tether. And if you are concerned about his being out, you can tether him to home confinement.
I did that the last time. And we keep ending up in the same situation. So what I say is let's get these done and then we can see where we can head from there. Motion for bond reduction.
This is where the emotional stakes rise dramatically. After the defense requests a bond reduction and proposes alternatives like home confinement, outpatient treatment, and electronic monitoring, the judge explains that similar opportunities have already been given in the past. In bond hearings, the court doesn't simply consider what a defendant promises today, it also looks at prior compliance with court orders and whether previous release conditions were successful. That history plays a major role in determining whether another release is appropriate. Do you think someone deserves another chance if they've already received several opportunities, or should the court focus on protecting the public first? The hearing now shifts to another defendant facing serious allegations. While the defense emphasizes the defendant's lack of prior criminal convictions, family support, and willingness to comply with strict release conditions, the prosecution argues that the nature of the allegations and concerns for the complainant justify keeping the current bond in place. It's important to remember that these are allegations presented during a bond hearing, not findings of guilt. The judge's role at this stage is to decide whether the existing bond conditions should remain while the case proceeds toward the preliminary examination, not to determine the ultimate outcome of the charges.
I think he has 2 previous convictions. I think that's what was indicated.
Okay, he thought they were dismissed.
Hey, anything else?
No, Your Honor.
Can I say something, Your Honor?
Not about the case,
Okay.
Mr. Davis.
All right.
What's your name, please?
Yes, Nathan Wade.
Preliminary examination will be in person June 20th, 2023, 9 a.m. before Judge Freshour. As to bond.
Your Honor, as it relates to Mr. Wade, he has 0 criminal record. I'll repeat, 0 criminal record. The allegations in this matter do not deal with any type of weapon. There is clearly some issues about a domestic matter as it related to the charging. He had complete access. Well, I'll move past that. He has a family support, his mother, his stepmother, his father, Erskine Wade, the boxer, runs Kronk Gym. The entire family is aware of the situation. He would promise to have no contact with the complaining witness. If the court would be inclined, he would ask to be released on a tether or a nominal bond in this matter.
Response.
Yes, Your Honor. Numerous things. As to the argument about that he had access to the home, it was actually at arraignment that the defendant himself said, the prosecutor said I broke in because I have the code, but actually I have keys. He actually had no permission to be in there at that time. The allegations in this case are very serious. They were formally dating. He was attempting to disable her home security, and every time he attempted to disable it, she would try to re-enable it. She was in fear for her life. He threatened to kill her. This is a situation where he laid in her bedroom until she got home, lying in wait for her. He then attacked her. He hit her repeatedly until she was in and out of consciousness. He then strangled her, upon with the threats to kill her. She did call 911. She was successful. The defendant then took the phone from her, threw it against the wall. She tried to escape, and numerous times, but he kept pulling her, preventing her from leaving. She tried to get down the stairs. She tried to make it through the floor, but he continued to pulled her back by her hair, punched her in the face numerous times. He prevented her from leaving. He continued to beat her until he was
By the end of the hearing, the judge denied each request for bond reduction and allowed the previously set bond conditions to remain in effect while the cases move forward to preliminary examinations. Throughout the proceedings, the court weighed the defendant's personal circumstances against the legal standards governing pretrial release and community safety. Although several defendants asked for one more opportunity outside of jail, the judge concluded that the existing conditions should stay in place until additional evidence is presented in court. What do you think about these decisions? Were the rulings appropriate based on the information presented during the hearing? Let us know your thoughts in the comments below. If you enjoy real courtroom breakdowns like this, be sure to like this video, subscribe to the channel, and turn on notifications for more fascinating courtroom stories and legal analysis.